Jamaican people want better. Economy coming like stormy weather. Ancestors are turning on them grave. To get change beyond, we can do it together. When we look at the future of precipice, we see Jamaica needs the vision of the PNP. People said the bag of promises, them can't carry go shop. And the crime rate getting higher, wonder when it does now come rest. Jamaican people want better. Economy coming like stormy weather. Ancestors are turning on them grave. To get change.
The proceeding was brought to you by the People's National. The following is brought to you by the People's National Party.
Make the trumpets play. Jamaican people want better. Economy coming like stormy weather. Ancestors are turning on them grave. To get change beyond, we can do it together. When we look at the future of precipice, we see Jamaica needs the vision of the PNP. People said the bag of promises, them can't carry go shop. And the crime rate getting higher, wonder when it does now come rest. Jamaican people want better. Economy coming like stormy weather. Ancestors are turning on them grave. To get change beyond.
The proceeding was brought to you by the People's National. The following is brought to you by the People's National Party.
Make the trumpets play. Jamaican people want better. Economy coming like stormy weather. Ancestors are turning on them grave. To get change beyond, we can do it together. When we look at the future of precipice, we see Jamaica needs the vision of the PNP. People said the bag of promises, them can't carry go shop. And the crime rate getting higher, wonder when it does now come rest. Jamaican people want better. Economy coming like stormy weather. Ancestors are turning on them grave. To get change beyond.
The proceeding was brought to you by the.
I went in, I switched it to the older mic setting. Sorry about that. All right, so good. Okay, doing this thing good. Thank you so much.
All right.
Sorry, got to edit out all of that. Sorry about that, guys. Okay, so really appreciate each and everyone. Says it's everybody's saying it's better now. Thank you so much. Really appreciate that. All right, so the topic for tonight is discussions for tonight: Ksamc, Haiti budget debate, and the Vybz Kartel issue. And again, please, guys, just send out some birthday wishes to Beryl Whiteley. Tomorrow is gonna be a birthday. Hope you have a wonderful day tomorrow and full joy your Earth Day. All right. So we are going to welcome persons in the chat, and I want to give a special shout out to our one channel member, Cynthia B. Bless up and thank you so much for joining the membership. And the membership is open up to anyone who wants to join. All right, so let me welcome those. Why did this slide come on? In the chat. All right, so Joan Morris, happy Friday to everyone. She says, Anthony R, welcome. Sonia Foster over there in the UK, happy Saturday. Cynthia B, our channel member, welcome. Blessed One, Fitzroy Palmer, the Isaacs family. The Truth, John Crow, Juliet Gooden, Inner Circle, Joey B, Carla Evans, Helen Richards, Lorado Patrick, that's another, Una Vassal, Avery Morrison, Merville Mackey, the Moyers Way, welcome, welcome, happy Friday, thank you so much for tuning in, Star Boy, Sonia Ellis, Diane, Karen, Dwayne Anglin, Raj, Derek Plummer, Candy Max, Angela 483, Montague James, Randy Bless, Dirk Plummer, Noel Wilson, Carla Ebanks, Lloyd Fang, Randy Bless, Sam Allen. Welcome. Lenford Wilson.
Blessings. So we just set it. So check it back. All right. Cool. Yeah.
All right. So I am going to turn over to Baron, and I'll monitor the chat and do some housekeeping. If I lose control of the chat, then I am just going to do umbrella welcomes. Also, we're supposed to be having 3 guests in studio tonight.
Let me speak on it. Let me speak on that.
Oh, okay. All right. So I'm going to hand over to Baron.
All right. Welcome to all our subscribers. Right. TV land, big up on yourself. Right. And of course, people in the chat. We want to say, thanks again to meet up with Mystic Sensation on a Friday. Okay, so we are going to be visited by, we have Major Robert Finzi. At current, the Major is in a seminar, right? And as soon as that seminar is over, then the Major will join us. We are also going to be joined by Dr. John Lennon in studio. We will be joined by Aromatic as well. And so then we are looking forward for tonight. And we'll be joined by Tara J. Vlog. So we're looking for an interesting night, right? And we have some quite intriguing topics to discuss, right? One of the first topics that we have to discuss is the issue with Vybz Kartel, and why it is important that we have to discuss this, because this issue, right, is actually bigger than Vybz Kartel, right? It's speaking about now a jurisprudence, right, as it relates to the studies of law. Vybz Kartel case is going to be a case law, right, that has to be studied, right? We have all aware of the ruling from the Privy Council regarding to Vybz Kartel. So as it stands, that the Privy Council, right, has quashed the conviction. So then Vybz Kartel has no criminal charges, or persons who charged with Vybz Kartel, they absolutely have no criminal charges, right? Now, the Privy Council, as we know it, right, had now sent the case to be decided on by the CCJ, the Caribbean Court of Justice. Now, I have some issue as it relates to that, because that ruling alone from the Privy Council, right, is now, challenging our entire criminal justice system, right, as it relates to them having it wrong, as it relates to why Vybz Kartel case, right, by the highest court, right, the conviction has overturned. What went wrong as it relates to our Westminster system, right, that, within that system, right, Vybz Kartel was found guilty, and then the CCJ, the Caribbean Court of Justice, also upheld the conviction. Now we are going to go through 2 main things, right, to understand what happened, right, as it relates to even the history of Vybz Kartel case. So we are going to look on what we call the burden of proof, which is very important and where people need to understand where we are going in terms of dealing with the Vybz Kartel case. I have also listened to Isaac Buchanan speaking on the victory as well. And I am going to deal with the Caribbean Court of Justice as it relates to, you know, them not observing, right, as it relates to when we have a tainted jury, right? And as a result of that, the tainted juror was the reason for the Privy Council, right, to quash the conviction as it relates to Vybz Kartel, right? So although Vybz Kartel is still in custody, anticipating now a determination from the Caribbean Court of Justice. So then, what I want to speak about, as it relates to why Vybz Kartel had found guilty in the first instance, right? Because remember now, the Privy Council had ruled, and as it relates to the tainted jury, right, the case, the conviction was quashed against Vybz Kartel. So let us get back into history, right, and ask why Vybz Kartel, right, reached here as it relates to him going through the Privy Council, right, and seeking justice, right? So we are going to make sure that we look on what we call the burden of proof for people to understand what went wrong. My determination, and let me say it clear, is that Paula Llewellyn had forced this conviction upon Vybz Kartel. And I'm going to explain it clearly to people for people to understand the reason why I said that such a conviction was definitely forced. Right now, let us hear what transpired as it relates to, right, the Privy Council making their final judgment as it relates to quashing that conviction.
Okay.
And by a majority of 10-1, convicted all 4 appellants of the deceased's murder. A 5th defendant was unanimously acquitted. Juror X was immediately arrested and was later convicted of attempting to pervert the course of justice. There was no evidence to connect his activities with the appellants. The appellants appealed against their conviction to the Court of Appeal of Jamaica, which dismissed their appeals. The Court of Appeal granted permission to appeal to the Judicial Committee of the Privy Council on 3 grounds, which were, first, that the trial judge failed properly to inquire into allegations of juror misconduct. Secondly, that the trial judge departed from standard practice in inviting the jury to retire to consider their verdict so late in the day, putting undue pressure on them to reach a verdict. And thirdly, that the trial judge erred in admitting the telecommunications data because it had been obtained in breach of the Interception of Communications Act and the Charter. The Judicial Committee of the Privy Council has unanimously concluded that the appeals should be allowed and the appellant's convictions should be quashed on the ground of juror misconduct, and that the case should be remitted to the Court of Appeal of Jamaica to decide whether to order a retrial of the appellants for the murder of Clive Williams. The board has considerable sympathy with the dilemma faced by the trial judge on the final day of a long and complex trial. Following the allegations of bribery, he had either to continue with the 11 remaining jurors or to discharge the jury. Despite this, The board considers that the approach taken by the judge was a material irregularity in the course of the trial, which makes it necessary to quash the convictions. This is for 3 reasons. First, the direction to the jury on the final day was inadequate to save the situation. The judge simply reminded the jury that they had sworn or affirmed that they would return verdicts in accordance with the evidence they had heard in court. The judge did not refer to the alleged bribery, of which, if the allegations were true, the jurors were already aware. Secondly, the trial continued with the allegedly corrupt juror serving as one of its 11 members. In the board's view, there should have been no question of allowing juror X to continue to serve on the jury. Allowing juror X to remain on the jury is fatal to the safety of the convictions which followed. It was an infringement of the appellant's fundamental right.
All right. Let us take that away.
To a fair hearing under the Jamaican Constitution. Thirdly, the judge should have considered whether the remaining jurors might have become, consciously or unconsciously, prejudiced for or against one or more of the appellants as a result of juror X's behavior. For example, there was a danger that the attempted bribe could have made the other jurors overcompensate, consciously or unconsciously, if they assumed that the offer must have come from one of the appellants and that therefore they must be guilty. The judge took no account of this risk. The board is very mindful of the serious consequences which may flow from having to discharge a jury shortly before the end of a long and complex criminal trial. It is also very conscious of the danger of deliberate attempts to derail criminal trials by engineering situations in which it is necessary to discharge the jury. In England and Wales, there is legislation which allows a judge in certain situations to discharge a jury because of jury tampering and to continue the trial by judge alone. There is no such legislation in Jamaica. It follows that there will be occasions where, as in this case, a court will have no alternative but to discharge a jury and end the trial in order to protect the integrity of the system of trial by jury. In view of its conclusion on the issue of juror misconduct, the board holds that it is not necessary to express a concluded view on the other 2 grounds of appeal. For these reasons, the appellant's appeals should be allowed. The court is now adjourned.
Okay.
My name is Steven
So
Sikowski. I'm the
let us
founding
take that
partner
away.
for Market Mastery Group. I understand all the nuances
All right, let us take
of
that
trading
away.
in Canada, which brokerage firms work, which
Oh.
ones don't. Probably 25% of all of our students
All right.
are Canadians.
So basically, we
And-
all heard what the Privy Council response was, right? And the case was quashed on the basis of the fact that the juror was corrupt and the ability that more jurors could possibly corrupt as a result of that one juror. Now, my argument is that the Caribbean Court of Justice, right, had upheld, right, the conviction of Vybz Kartel, right, prior to Vybz Kartel going to the Privy Council. As a result, and which is very important, and one of the reasons why we have to touch this Vybz Kartel case, right, because I presume that other persons, right, may in a similar position as it relates to being into prison, found guilty, right, on similar situations, and as a result of them not having the capital injection like Vybz Kartel, right, suffers a serious dilemma. Now, based on what the Privy Council is saying, that there is no legislation in law, so I am not blaming the judges, at the CCJ, right? Because there is no legislation that said, okay, if a juror is corrupt, right, then the judge should dismiss that juror. There's no legislation, right, in that. And so then I am saying, as it relates to the Westminster system, the well-learned friends who have been dealing with situation like that, and where the possibility exists that a juror might be corrupt by through any means, right? Why there was no amendment put in place to deal with situation like this, but yet the CCJ wanted to be the final court of appeal. Now, if the CCJ had been the final appellate court, there you go, Vybz Kartel, right? And his charges wouldn't have gotten a second chance, right, to claim, right, what they believe that injustice was done. They wouldn't have gotten it. And so then my argument today is that I am wondering that if we need to have the CCJ as our final appellate court, or we need to still hold on to the Privy Council, right? Tara, I am going to make you speak, but let me just go through other persons will be joining us later as it relates to, but I want to set the foundation of certain things, right? Now, let us go back now to the fact that, okay, that is the problem I have with the CCJ. The CCJ itself failed to recognize that the juror was corrupt. And as such, right, a conviction should not prevail. Let us understand what transpired and the reason why the Privy Council quashed the conviction as a result of a corrupt jury. Now let us go beyond that now. I finished dealing with the CCJ. Let us look as it relates to Paula Llewellyn, right? As it relates to the first development of the situation with Vybz Kartel, right? And the allegation, right, of Vybz Kartel committing number 3. So let us look now. What we are going to deal with is what we call, to my knowledge, the CCJ was not involved in this matter. No, Daniel, what happened as it relates to the CCJ, right? When Vybz Kartel made the appeal to the CCJ upheld the conviction. So that is what I'm saying. So the CCJ previously upheld the conviction, as you have heard a while ago in the clip. You understand, as it relates to the Privy Council response. And one of the reasons why that conviction was upheld was to the fact that there's no legislation at all that would say, okay, all right, if you have a corrupt juror, right, that the judge should dismiss that juror. There's no legislation, there's no law. And so then the CCJ, right, based on other evidence, right, upheld the conviction. So that is a part that the CCJ played. And I am saying that, okay, all right, the CCJ have well-learned judges and all of that, right? Couldn't they be more proactive in saying, okay, all right, we need to have a law in place that if the possibility of a juror, you understand, get corrupt and to contaminate the entire juror pool, right? We should put a law in place, you understand, to deal with that situation. Right, Sirin Sue, it wasn't the CCJ, it was Jamaica Court of Appeal. Okay, all right. Okay. Thanks for the correction as it relates to the Jamaica Court of Appeal. My bad there. So thanks for the correction. So the Jamaica Court of Appeal, right? Let us correct that. Right? Upheld, right, that conviction. And so then that is problematic as it relates to the Court of Appeal. So now let us move on now to, we are going to look into the investigation that lead to Vybz Kartel being arrested and charged, right? Now, what we are going to look on to have an understanding to say, okay, whether or not Paula Llewellyn forced a conviction, right? So the next document that I'm going to present, we are going to present the proof beyond a reasonable doubt, right? The weight of evidence. And let me just explain certain things, because there are different weight of evidence as it relates to certain charges, right? When it comes to civil matter, we talk about the preponderance of guilt. Now, when we talk about criminal matter, the weight of evidence is different. You have to prove, it is on the prosecution to prove that case beyond a reasonable doubt. So now let us look on that and to see where Paula Llewellyn actually went wrong. Now, I have 3 issues with it. Number 1, the tampering of data. Number 2, no body was found. Number 3, the tainted juror. The tainted juror. So let us look what the proof beyond a reasonable doubt stated. I am going to make you all read it. Now, without any further ado, let us bring up that document.
Okay. Again, happy Friday, everyone. Thank you so much for tuning in. Okay, let me just make sure it is being shared.
And set it to 200 so that they can see that.
200.
Okay. So let us all read what proof beyond a reasonable doubt, what it means beyond a reasonable doubt. And this is what the prosecution has to have Vybz Kartel and persons who charged with Vybz Kartel, right? They need to have and make sure that they meet the requirement of this before Vybz Kartel can be sentenced. It reads, beyond a reasonable doubt is the legal burden of proof required to affirm a conviction in a criminal case. In a criminal case, the prosecution bears the burden of proving that the defendant is guilty beyond all reasonable doubt. This means that the prosecution must convince the jury that there is no other reasonable explanation that can come from the evidence presented at trial. In other words, the jury must be virtually certain of the defendant's guilt in order to render a guilty verdict. This standard of proof is much higher than the civil standard called preponderance of the evidence, which only requires a certainty greater than 50%. Take that document away. Take that document away. The reason for me to utilize, to share Sonia Ellis, am I to understand that our so-called lawyers and judges did not know there was no rules in the law to address jury tampering? Well, Sonia, it is what it is. There was no rules, right? There was no law in there to address it. And that's why it is a serious dilemma. And so then, that's why I am bringing all of this out. To say, imagine there is no legislation to address jury tampering. And all of that now would have left on the discretion now of the judge. And where wisdom would dictate that, come on, if a jury, you understand, got contaminated, then it's more likely that the entire jury pool can be contaminated. And I am surprised that there is no law, right, as it relates, let me see that there is no law as it relates to what can put in place to protect that sort of system. Just imagine a Westminster system that we are using from Wapia till Philip for how much 100 years, right? And you are going to tell me that there is no law that exists, you understand, to avoid all of that. Seems like there was no amendment because they want to be able to use jury tampering in their favor, right? So just look at that, Sonia. And this is one of the reasons why we are discussing this. And Deborah, it will get worse if they change the constitution when they become republic under the current government. So that's why we are going to juggling down now and use now for people to understand now the burden of proof. So the burden of proof, right, which is that needs to utilize in a criminal case is proving the case beyond a reasonable doubt. So let us ask the question. Did Paula Llewellyn prove the case beyond a reasonable doubt? Absolutely no. Number one, let us look at all the doubts. One of the first things, right, there was no body presented. We know that, okay, although there is no body presented in several cases, right, person still, right, found guilty based on other evidence, right, that are, you know, concrete evidence, you understand, and that can prove beyond a reasonable doubt. So we understand that. But look now, we have the situation, right, where the Privacy Act was breached, right? Paula Llewellyn did not care about that. We have another situation which now results in the conviction to overturn, which is the poison juror. The juror that has been tainted, which in extension lead to the possibility of other jurors may have formulated a conclusion. So then one will look and one will say then, okay, all right. But why the jury was tainted was to the fact that the jury want to pay persons to say that Vybz Kartel is not guilty. Okay, all right. Put it that that's maybe the case. Now that jury, or whether the jury refuses or no, and conversing to other jury, would have now formulated an opinion in other jury to say that, okay, then it is rumored that Vybz Kartel is paying a jury to corrupt other jury, right? Then Vybz Kartel must be guilty, right? Without the evidence, right, to say that Vybz Kartel indeed pay a jury, you understand, to poison the jury pool. So then, to every juror that received that information is now saying to his or herself, Tara, that if Vybz Kartel is paying, right, a juror, right, to contaminate, then Vybz Kartel must be guilty. So the perceived notion of guilt rests in the juror's mind. And so then what the judge should have done, right, is to clean that juror pool, right, to avoid the contamination. The judge did not do that. And now they allowed the case where Vybz Kartel, in pursuit of defending himself, now we are the Privy Council look at it, right? And for the very same reason that a juror that has been contaminated, that has been poisoned, has the ability, right, to poison the entire jury pool. And so then a verdict that presented by that particular jury cannot be in good faith. My argument is for the judge to not having that understanding, I am a bit worried. For the prosecution, as it relates to Paula Llewellyn, not having that understanding, I am a bit worried that many other cases, right, apart from Vybz Kartel case, may have gone the very same way in terms of a conviction forced upon them, breaching certain procedures and breaching certain fundamental rights of the accused person. So let us look into the truth. Now, I am going to play a case, show people a case in terms of how Paula Llewellyn processed justice. A case where Vybz Kartel, in Vybz Kartel case, there was no body, right? However, that case still proceeds. But I am going to play a clip and show people, right, why we have such a difference when it comes to Paula Llewellyn. Without any further ado, play the clip that I just keep it to you.
Okay. But is it sharing? Yeah, it's sharing.
2016, the body of 51-year-old Jermaine Jr. was found with multiple stab wounds and a single gunshot wound to the head in the reception room of attorney Patrick Bailey, who just happened to be a close friend and lawyer of Prime Minister.
Okay.
Okay.
Oh my goodness. All right. But what will happen with the other video first? Okay, guys, sorry about that. Just gonna start playing the video again.
So if we're gonna have a problem with the other videos, we'll continue this.
Murder most foul. On September 30th, 2016, the body of 51-year-old Jermaine Jr. was found with multiple stab wounds and a single gunshot wound to the head in the reception room of attorney Patrick Bailey, who just happened to be a close friend and lawyer of Prime Minister Andrew Holness. A knife, believed to have been the one used to stab Jermaine Jr., was also found beside the body. Patrick Bailey and Jermaine Jr. had an attorney-client relationship for 20 years prior to the murder. Around 1996, Jermaine Jr. was mistakenly shot multiple times by the police in Hope Pastures, St. Andrew, after they received a report that a robbery had occurred in the area. The police believed Jr. matched the description given in the report. Bailey represented Jr. in the lawsuit that was filed and won. That's how they became friends. The facts of the case are that while Jr. was in the United States, he paid his attorney to buy a property for him. When he returned to Jamaica, he discovered that his money was missing and no property. Jr. and Bailey came to an agreement that Jr. would stay in one of Bailey's houses until his money was returned. The house Jr. stayed was a house in the same yard of Bailey's main house at the back. This was not the first time Bailey was accused of stealing clients' money. In 2015, Bailey was arrested on charges of conspiracy to defraud in connection with a land deal that took place in 1996. The police alleged that a property was transferred to another person without the owner's knowledge. In 2022, Bailey was struck off the roll of attorneys eligible to practice in Jamaica for failure to handing over $17,640 to a client. Bailey collected money from a client and held it on trust. When the person requested the money, Bailey made several promises to hand it over, but that was never done. Bailey also represented Andrew Holness in the purchase of land on which his Beverly Hills mansion is built, via a St. Lucia registered company that Andrew set up to purchase the land while he was on a visit to Jamaica, as falsely written on the purchase documents. Documents from the National Land Agency showed that Bailey was the attorney who witnessed the notation at the time the property was being transferred. On the night of the murder, Bailey told the police that he stumbled on the body at 4 a.m. and had not heard anything. Bailey claimed that he was fast asleep when the killing occurred. The police said that there were no signs of forced entry. Police Commissioner Major General Anderson is cousin to Andrew Holness. For some reason, Bailey was immediately ruled out as a suspect. The morning after the murder, Bailey was reported to be unwell, and his doctor, who also happened to be one of Bailey's clients, Jeff the Ford, informed the police that he should be confined to bed and was not fit to give a statement at the time. In 2014, Jeff the Ford was found guilty of corruption after he tried to bribe a police officer to release 2 Surinamese men who were caught with nearly $60 million. He was sentenced to 6 months in prison. It is alleged that the JLP Member of Parliament, and attorney Orlando Terrelonge, who is the legal partner of Bailey, was involved in the murder of Junior. The police reported at the time that men from the Umbrella Gang in Orlando Terrelonge's constituency were under investigation for Jermaine Jr.'s murder. Orlando Terrelonge, who is openly gay, is alleged to have been in a sexual relationship with Patrick Bailey. According to Jermaine Jr.'s brother, David Roberts, it makes no sense to seek justice because nothing will come of it. The police damn know who did it. The police have faced public criticisms over their handling of the investigation. The average Jamaican citizen would not get off this case as easy as Bailey has. Corruption permeates the legal system. It will only end when Jamaicans say, enough is enough.
All right. Now, so since I presented that, right, and we look, and of course, we have read the document that I presented earlier as it relates to the burden of proof, the weight of evidence. And one of the reasons why I use that is to the fact that when you look on the burden of proof evidence, to say that to prosecute this case, the onus rests on the prosecution. When it comes to a criminal case, that the weight of evidence has to carry the highest proof of evidence, which is prove the case beyond a reasonable doubt. So, ladies and gentlemen, we have seen in Patrick Bailey's case where the body was found in Patrick Bailey's house. There was no tampering, Tara, right, as it relates to persons coming from outside, inside. The weapon of choice that used for the murder was found. The fact of the matter why this is extremely serious is that Patrick Bailey has not been charged for this particular case. In comparison to a Vybz Kartel case, where lizard body, the deceased body, has not been found, has not been discovered. God not sleep, only a matter of time. God have a way of showing up. Yes, Becky. And so then, when you look at that, I want to play a clip as it relates to what Paula Llewellyn had said at a seminar, right? I have been seeing that, okay, I am getting some technical difficulties. I don't even touch the cases, the case I may see where the bug of corruption is. I don't know if, Tara, you think they are trying to avoid me from speaking about the bug of corruption tonight? I don't know. But, you know, guess what? The devil is a possibility. We are going to speak about the bug of corruption in the case MAC because we have the evidence. Right? We have the evidence. So we are going to tag along. We know that, okay, all right, the devil is working hard tonight. Now, so the question that I'm asking, right, that I am going to show a clip where Paula Llewellyn is saying into the clip that the prosecution and the investigators need to work together to have a successful prosecution. So Paul Llewellyn know very well to have a successful prosecution into a criminal matter, right? He has to prove the case beyond a reasonable doubt. That is why I present that document. And so then what the law dictates, the law said, if you have the slightest doubt, this is what the law says, then the accused must set free. If you have doubt, the accused must set free. Now let me ask the question. Is there doubt in Vybz Kartel case? It goes beyond doubt. It goes beyond procedural error. Because when a case goes to the Privy Council don't try over the case. Nothing like that. What the Privy Council does is to look on procedural breakdown. So then, not only that, you did not have the substantial burden of proof. You understand? The weight of evidence, which is beyond proving the case beyond a reasonable doubt. You have serious procedural flaws. And so then when I said that the prosecution forced the conviction, number one, knowing very well that one of the jurors was tainted. No, number two, the possibility of that juror being tainted has the likelihood to corrupt other jurors. Right? And Paul Llewellyn still go beyond that. Now to what? Prosecute the case. That is a fundamental wrong. So without any further delay, let me show you that Paul Llewellyn herself said the prosecution and the investigator need to work together. And so then Paul Llewellyn is saying it takes a prudent prosecutor to do that. So without any hesitation, let me play you and you listen to Paul Llewellyn. And you are going to wonder to yourself if Paul Llewellyn apply the same principle in every cases. Because if Paul Llewellyn apply the same principle in every cases, I am asking Paul Llewellyn, when it comes to Patrick Bailey case, did you work with the investigator, trying to dot all the I's, cross all the T's, right? You have the weapon that's used to commit the number 3. You have the body, Paul Llewellyn. There is no tampering, Paul Llewellyn. And so then, why there is no charge so that Patrick Bailey can place through a judiciary for the judiciary to decide on it? So we want...
Okay. Sorry about that. So I'll put out the notification as soon as we figure it out and coming back. All right. Thank you so much for your patience. Really appreciate. We tried, but it's still happening. So we have to fix the issue and then come back.
Just give us 10 minutes to do that.
It don't take me more than 10 minutes to put back all of this, because once I end the live, I'm gonna lose everything and I have to put them back. No. So all right, guys.
Another half an hour till then.
I said I'll put out the notification. I don't know exactly how long it's gonna take for Shimmer to figure out exactly what the root cause is. All right, guys. So we'll be back shortly.
All right.